Provident Healthcare Partners is a healthcare investment bank that is focused on transaction advisory services. We created this podcast for healthcare executives, entrepreneurs, shareholders, and providers who are interested in learning more about the world of healthcare consolidation.
Welcome to Provident's podcast. I am AJ Shekar, a director with Provident. Today's conversation topic is on healthcare regulatory updates. In particular, there's been a lot of news over the last several months around federal and state scrutiny toward healthcare provider transactions. This is certainly a topic that's top of mind for private equity groups, investment banks, healthcare attorneys, executives, and shareholders of healthcare businesses that are active from an M&A standpoint across a whole spectrum of different specialties. So we wanted to publish this podcast and also bring a guest with us who has been very active in helping various healthcare constituents navigate some of these changing waters from a healthcare regulatory standpoint. So we're excited to have Katherine Douglas, who is an attorney with Fredrikson and Byron, join us for the episode here today. Katie, thanks again for joining us. If you wouldn't mind, it would be great for our listeners to hear a little bit more about your background and your firm's background as well.
Thanks, AJ. Thanks for having me here today. Again, I'm Katherine Douglas, a shareholder in Fredrikson and Byron's healthcare group. Fredrikson is a approximately 400 attorney law firm based here in Minneapolis, but provide legal services across the country for our clients. I am in our healthcare group. I focus my practice on transactional and regulatory advice for our healthcare clients. Part of a much larger firm, we are a full service firm here at Fredrikson, so we have a very robust M&A, private equity group, as well as all of the ancillary departments and industries. So again, I'm very happy to be here and to be part of this discussion with you today.
Thanks, Katie. So one of the topics that I mentioned off the top that would be great to start off with is just around the new and emerging healthcare antitrust issues and approval processes that groups have needed to navigate over the last few months and something that is likely to persist over the next few years. One key theme that has been a backdrop to that is really something that's culminated over the past 10 or 15 years, where overall, there's been a federal and kind of overall push within the U.S. healthcare market to reduce cost of care, improve patient outcomes, enhance access to care services as well. What we've seen, at least from an investment banking perspective, and Katie, I'm sure you're seeing it too, is that in order to reduce cost of care and gain additional access to resources to provide more expensive care throughout the United States, many groups have turned towards consolidation as a way to create back office efficiencies, gain capital through investments from private equity firms to fund the build out of value-based care services, et cetera, with the thought that larger businesses would better address some of the complexities in the changing healthcare landscape. At the same time, I think that consolidation effort has led to more regulatory scrutiny with the concern around healthcare monopolies in certain markets that have the potential to increase cost and likewise potentially reduce competition and access to care as a result in certain markets. So I think just coming out of that sort of concern and fear from a regulator's perspective, we've seen a couple notable kind of news-grabbing developments. I think first was the FTC's lawsuit in 2023, I believe it was, against U.S. Anesthesia Partners. And, interestingly enough, looping in its private equity partner specifically as well, Welsh, Carson, Anderson, and Stowe, alleging that they had consolidated markets to drive up prices in the anesthesia space. And I think, a lot of folks within the healthcare M&A world were surprised that the private equity firm was also named in the suit, which I believe was dismissed over the last month or so. But But that's certainly kind of one interesting development from a federal standpoint. And then we've also seen several states implement their own review processes to make sure that some of these healthcare transactions aren't creating monopolies or adding costs to the system as well. Katie, be curious to get kind of your perspective on what kind of the quick Reader's Digest summary is of some of those new kind of regulatory policies from federal perspective, and any commentary you can share from, a state by state perspective around what kind of groups the regulatory groups are trying to prevent, and just generally how groups, should think about navigating some of those recent issues as well.
Sure. Yeah, I mean, AJ, I think you're spot on in that certainly at the federal level, the FTC has made it very clear that it's targeting activity and consolidation, specifically private equity ownership and involvement in the healthcare industry. Just this past spring, the FTC, the DOJ, and the Department of Health and Human Services, they all joined forces and had a workshop in the spring, just kind of examining the role of private equity in healthcare. And it was quite interesting to listen to. It was a day long, and they had various stakeholders within the industry give testimonies and accounts of what it's like, let's say, for example, since a private equity shop acquired their hospital. So it was kind of a parade of horribles, and didn't, certainly focused a lot on hospitals, rural hospitals especially, and kind of access to care. But they did kind of gloss over the kind of pros that you had mentioned, AJ, in terms of private equity investment and strategic investment does bring kind of much needed efficiencies and innovation, and also allows for bigger capital investments to improve patient care. But nonetheless, here we are. It's definitely an area of focus. And at the state level, states have also gotten into the game and have developed what some people kind of call the baby HSR statute. So that's kind of a reference to, Hart-Scott-Rodino, which requires FTC approval of certain large transactions. And I think until now, or until recently, private equity transactions, especially in the add-on space, were free from any sort of scrutiny because they didn't rise to the level, the dollar level or size level that would otherwise trigger a review at the FTC levels. I think at the last count, there's probably about 15 states that have some sort of healthcare transaction notice or consent requirement. I think the most recently might be Indiana, which goes into effect in July. But these state laws are constantly evolving, constantly changing. They vary greatly state to state. There are some common themes. First is the types of entities that these transaction laws are targeted at. Often it's hospitals. Physician practices are probably a distant second. Could be surgery centers, private equity sponsors. Some states will have these kind of amorphous definitions of provider organizations, and can get really nuanced on what's considered a provider organization. And broad interpretations could pull in, for example, an MSO, a management services organization, or a dental services organization. The types of transactions, obviously kind of run-of-the-mill acquisitions, but they could also be joint ventures or revenue sharing agreements. So it's also important to kind of look at the type of transaction that's targeted, because even if you're not doing an acquisition, it might still be triggered. They'll often have revenue thresholds associated with these notice requirements, and sometimes there'll be staggered revenue thresholds. So certain revenue level may require a heightened level of review. States also vary on what needs to be disclosed and to whom. In some cases, you may be reporting to the state's attorney general's office. Sometimes it's the Department of Health. Sometimes you have to give a description of the transaction, and other times it could be you got to provide the deal documents. And so it's important to think about what's going to be disclosed, because in some instances, whatever you disclose could be subject to an open records request. And so you might lose some confidentiality if you disclose too much. The timing of the disclosure will also vary state to state. Usually it's 60 to 90 days advance notice, but oftentimes the agency at play will maybe have discretion to extend that requirement or to extend the time of review. So even if it's a 90-day notice requirement, it might take them 200 days to review and sign off on the transaction. It's usually a notice requirement, but it's possible some states do actually require a kind of a stamp of approval. And then obviously the penalties vary from state to state. You got to look at what sort of consequences you could face if you fail to make this disclosure. So it really does kind of run the gamut of terms of types of transactions, what needs to be disclosed, the level of review, the timing of review. And unfortunately, there isn't a kind of a cookie cutter approach to these healthcare transaction laws.
That's a great overview and synopsis, Katie. And I think that the last point you mentioned is something that I think is top of mind and should be top of mind for groups that are continuing to invest into healthcare or undergo transactions themselves, is that there's a lot of different kind of rules and regulations based on even the specific state that you're in. Out of curiosity, and maybe we could even use Minnesota as an example, given that that's the state that both you and I are located in. How is it kind of played out in practice for one of your clients that's sought to go through a transaction? What is kind of the review process been? How did that deal ultimately go over the finish line? And ultimately, what best practices would you kind of give someone in a situation where they're in a state that requires some of these kind of pre-transaction review and notification requirements?
Yeah, sure. So Minnesota's law is relatively new. It came into effect just last year. And so, we had one situation where I think we might have been the first or one of the first transactions to become subject to the review. And, I think the key is approaching the state early and being cooperative. Because it was new, everyone was kind of learning as they go. And I think the review process will evolve over time in Minnesota as well as other states as they get more of these transactions under their belt and start to understand what exactly it is they care about. But I also think it's important to be mindful about what information is being disclosed. I think what's been a successful approach for us is provide the information that's required and that is helpful for the state to do its review, and don't bog them down with kind of unnecessary information that, frankly, doesn't really help your case. And I think causes delay, could cause confusion. And so we took that approach and, ultimately the transaction went through, kind of no further follow-up required. So, I think the key there was just, again, being cooperative with the state, providing them the information they need without kind of bogging them down with unnecessary information, being responsive, and they were pretty easy to work with in that situation. And I think that's, the good advice for any state that you're operating in is just, again, keeping an open line of communication and really making sure that you're helping with respect to what's the real purpose of the review. That's been my experience so far, and I'll kind of knock on wood that it kind of continues that way, but we'll see.
Absolutely. And congratulations getting that one over the finish line. It's always tough to be the guinea pig in situations like these. And we've been a part of some other transactions in particular where before some of these processes were enacted, we really wanted to get the deals over the finish line as quickly as possible, not to be that kind of sacrificial lamb, I suppose. Right. So, good on you guys for being the first one to go through that, or one of the first, and seeing through it on the other side. The way that we've also been thinking about it internally is that it's important to have all the kind of parties at the table align on any sort of consents and approvals and notifications as early on as we can, just so there's a kind of clean path in place towards getting those across the finish line and just setting expectations, like you mentioned, that it might just elongate some of these processes in order to make sure that the state regulatory bodies are getting the information they need and kind of responding within a reasonable timeline. Not unlike some of what we've seen historically with deals that required the Hart-Scott-Rodino notification or others, like, for instance, state of New York transactions that required, some lengthy Department of Health approvals as well. But I think just kind of part and parcel for working in healthcare, but albeit a little bit more pre-process and pre-transaction planning than maybe what happened previously. But curious to get your take on this as well. We've certainly been to several conferences and talked with investors where people are trying to game plan as far as how some of these rules impact kind of overall consolidation going forward. I think there's something to be said that those states that have stricter laws may be ultimately more challenging for new private equity investment, whereas states that are maybe further behind enacting some of these approval processes might see more transaction activity. What's your kind of best guess as far as how some of these rules, especially with the antitrust approval processes, will play out with transaction activity and new platform M&A activity across the US?
Yeah, I mean, so I don't really have a crystal ball, but I agree that definitely the states that seem to be more kind of problematic or causing large delays, I definitely would anticipate that at least new investment in those states will probably slow. I think it also depends on the industry. A lot of these laws, they don't apply to every type of healthcare transaction. And so, while you may see fewer assisted living deals or hospital consolidations in certain states, it may have no impact on dental deals or, ASC deals. And so it probably depends a little bit. I think states should also want to be a little careful these laws having a chilling effect on investment within the state because, while obviously decreasing competition and increasing costs can be a real concern, I think you also want to balance that with making sure patients have access. And I do think that continued investment in a state will usually lead to kind of continued activity and continued access and options. So I'm trying to be optimistic that it's not going to mean that kind of deals will come to a screeching halt in certain states. I would assume that states wouldn't want that either. It's also possible we see, we're talking a lot about consolidation and we might start to see unwinds. And so that could be interesting as well. I haven't seen too much of that play out, at least at kind of the lower level, but that certainly could be a result of this as well.
Yeah, the unwind part is very interesting because you think about some of the fallout that could happen from, let's say, an unwind of a large organization and maybe some of the threats to actually providing good quality care in the midst of that sort of turmoil. That would be an unintended consequence, I think, of certain groups not getting the approvals or getting unwound by regulators. It was interesting. We were at another conference where there was a panel of CEOs that were from several kind of large, well-respected physician practice MSOs that were backed by private equity. Another thing that they mentioned was that at the end of the day, the motto that they're living by is good medicine is good business. And if they can continue to capture and show the data that what they're investing into is creating value versus just driving up costs is going to be a key tool in ensuring that healthcare delivery goes unaffected and improves as a result of some of these transactions, and pointed to especially the efforts of a lot of venture and PE-backed groups developing in concert with payers new value-based care methodologies that ultimately is aimed at driving down the cost of care. It seems like there should be kind of logic in allowing those sorts of transactions that are benefiting the healthcare ecosystem to continue. So I think it'll be interesting to see, like you said, Katie, cautious optimism that, cool heads prevail and M&A activity that is still beneficial to the healthcare environment continues. But I guess more to learn on that front over the next few years, and just makes it super important to have very knowledgeable and qualified advisors who have navigated this from, all standpoints involved in these sorts of transactions. Maybe the second point that has been top of mind for a lot of groups undergoing M&A or investing themselves into healthcare entities has been some of the updates to use of non-competes in transactions. And so ultimately, I think what we've seen, even in some states Prior to this new kind of rule unfolding or set of rules unfolding state by state, there were previous restrictions in areas like Massachusetts and California on enforceability of non-competes for physicians in particular. But now it seems like there's maybe a broadening of that sort of definition for healthcare providers, again, in an effort to ensure that access to care is left unencumbered as a result of transactions. If you wouldn't mind giving kind of our listeners a quick summary, Katie, of what the historical guidelines were around kind of non-competes for healthcare providers, how some of these new guidelines might differ from what we had seen in the past. I think that would be a helpful way to just kind of frame some of the ongoing dialogue that's been happening around non-competes in this space.
Yeah, I mean, so historically, and I guess still technically, non-competes for physicians, healthcare providers, all employees, frankly, have been and continue to be a matter of state law. States vary widely on their attitude towards non-competes. Some will be directed kind of at certain types of workers or employees, physicians, healthcare providers, for example, or also, oftentimes it can be income-based. So low-wage workers are sometimes, there may be laws protecting them from non-competes, whereas high earners above certain compensation thresholds, non-competes may be fair game for those types of workers. So it's been kind of all across the board. Very few states, Minnesota, one of them just recently, have kind of blanket restrictions or bans on all types of employee non-competes. But as everyone kind of is well aware, the FTC recently proposed a nationwide ban on all employee-based non-competes. It's set to go into effect early September 4th, and it would apply to all workers regardless of industry. There are some exceptions for existing non-competes for what are known as senior executives, and that's got a definition within the law that basically looks at whether the employee's in a policy-making position and whether they make roughly over $151,000. It's a really specific number, but non-competes for those type of employees could still be enforceable, but only those that are in existence. You couldn't enter into new ones. There is an exception also for the sale of business, non-competes in connection with the sale of a business, and we can get into that a little bit more. Interestingly, the FTC ban does not apply to nonprofits. And that's because basically the FTC doesn't have jurisdiction over nonprofit entities. And so in the healthcare space, this really creates an interesting situation because you've got for-profit entities that could be subject to this non-compete ban, while nonprofit hospitals, on the other hand, may still be able to have enforceable non-competes. So, that could create a very interesting landscape, at least for physicians and other providers that are kind of potentially hospital employees. This all being said, the ban is being challenged in a few different courts around the country. And the general argument against the ban is that the FTC doesn't have the authority to issue a nationwide ban on non-competes. And we've actually seen some activity recently on two of the cases. So first, we've got a case in the Northern District of Texas where challengers are seeking a nationwide injunction blocking the FTC from enforcing the rule. And on July 3rd, the judge in that case granted the plaintiff's motion for a preliminary injunction as to some of the plaintiffs. But the judge did stop short of issuing a nationwide preliminary injunction. So again, this was a request for a preliminary injunction while the case was pending. And the judge in that case will make a final ruling on the challenge by August 30th. So in this case, this is certainly an initial strike against the FTC. And on the other hand, a second federal judge, this time in the Eastern District of Pennsylvania, denied the plaintiff's motion for a preliminary injunction in that case. So unlike in Texas, this was not a request for a nationwide injunction. It was just a request for an injunction in favor of the plaintiffs. but it failed. And so the plaintiffs in this situation were, or in this case, were a small tree trimming company. But so the FTC got a win in that case. So this all kind of goes to show that there is a little bit of uncertainty around if and when the FTC ban will go into effect nationwide and whether it will be on September 4th. And we'll all be watching very closely in the next coming days to see what happens. It's also worth noting that regardless of how the FTC ban shakes out, the FTC does still have authority to investigate specific transactions or provider practices, specifically their non-compete practices. And for example, there's an ongoing investigation of DaVita and Fresenius and their use of non-competes in their medical director agreements with nephrologists. So it's possible the FTC could take a more granular or pointed approach to questioning non-compete practices among healthcare providers, even absent a nationwide non-compete ban.
That's a great overview. It's a topic that has come up in conversation a lot for us recently, especially as we chat with our friends in the private equity community about the best ways of ensuring there to be kind of post-close alignment, especially with these provider-based businesses that have been undergoing a lot of investment and consolidation from private equity. I'd be curious to get your take as far as any ways you've seen groups adjust their approach based on this kind of impending guidelines and guidance. To your point, there's a good chance that it doesn't happen at all. But it seems to us that like a lot of groups are taking the approach of going beyond just kind of enforcing non-competes, but rather going to the original source of how to better create stickiness and alignment with physician and provider groups in particular, whether it be through having some sort of like equity vesting clause over time, from a strategy standpoint, trying to figure out opportunities for income repair to those physicians and making sure that their lives are better post-transaction than they were pre-transaction, and ultimately giving a lot of kind of clinical autonomy and governance rights to the physicians in the group who are obviously driving a lot of the revenue in these transactions. But curious to kind of get your take as far as, and maybe there isn't necessarily too much in the way of substantive changes, but ways groups are trying to supplement any sort of like non-compete utilization with other transaction structuring approaches to make sure that they can still keep these providers sticky with the business going forward.
Yeah, I mean, as I said, I am reluctant to have clients kind of do anything too drastic in anticipation of the FTC ban, but I think it is, to your point, important to kind of look at the policy behind the non-competes, and really you're concerned about people leaving and becoming a competitive threat. And so how do you prevent those people from leaving in the first place? And so certainly, retention efforts, I think to your point, equity vesting clauses, creating equity incentive plans, using things such as profits interests and just other tools to give the providers kind of an aligned interest in the success of the overall enterprise. So, and those are really tools that we've seen in play already. And so they're not too foreign, but, I think probably if some sort of ban does come into effect, or frankly, in Minnesota, we have one. And so, having to kind of use those tools to keep employees aligned. In the transaction context, and this is probably more in connection with the sellers, which, as I mentioned, non-competes in connection with the sale of the business are still alive and well. And I think courts do recognize the importance of preserving goodwill following the acquisition. But even the use of tools such as earnout can help. Obviously, there are kind of regulatory considerations to be made depending on whether an earnout will work from a compliance perspective. But that's another way to kind of align physicians and providers with the kind of overall enterprise. Non-solicitation provisions. I've got clients who maybe, they had a non-compete, but they don't really have a very robust non-solicit or kind of trade secret confidentiality provisions. We're having clients kind of beef those up, again, to protect employers' interests. And so that's another tool that, you can use day in and day out, but then also become helpful in the deal context. Because, as a buyer, if the sellers workforce is at risk of leaving and doesn't really have anything kind of keeping it there, I think it becomes a less attractive target. And so it's important, even just pre-transaction, to kind of have a healthy workforce and the right protections in place.
Absolutely. Katie, are there any other kind of key regulatory updates or things that you're keeping your eye out for in the next, call it, year or so that our listeners should be aware of? And curious to get your thought as well. Obviously, 2024, it's an election year. We get questions asked about how things could change if there's either continuation of the current administration or potentially new one. How do you kind of counsel clients who ask you about how things could potentially change in the next year or so? Any thoughts along those lines?
Well, I try to avoid giving too much advice on how I think things might change, because it's who knows, right? But, in terms of kind of other topics or items that we've got on our radar, there's a lot of innovation in the healthcare industry right now. For example, let's say the med spa area. I wouldn't be surprised, and I'm kind of watching for more regulation in some of those areas that are booming, that are kind of not super regulated right now. And so I think preparing our clients for potential change in that regard. And, you're seeing more previously unlicensed providers, or not even providers, but personnel. Suddenly there are, new licensing requirements popping up in various states. And so I think just really keeping an eye on the activity from a legislation perspective in terms of previously unregulated industries or aspects of the industry that maybe are becoming more popular. And I think as they become more popular, states may say, hey, this is an area that we should focus on, and maybe make sure there's a little bit more regulation just to protect patient interests. And so that's kind of what we're looking at. But, I think really this non-compete and the healthcare transactions, that's kind of keeping our plate full at the moment. But it really is just kind of sending the signal, I think, of government oversight and being prepared for that. Reimbursement is a whole another issue as well, and kind of various reimbursement models that are coming into play. And so just kind of, again, keeping our finger on the pulse of the ever-changing environment in that regard as well.
Absolutely. The reimbursement topic could probably be a whole separate podcast based on all the changes that continue to happen within, all the variations of the healthcare space, and especially as value-based care becomes more and more prevalent. So we'll have to have you back another time to chat about that in more detail, I'm sure.
That'd be great.
Great. Katie, thank you so much for your time. I think this has been a great discussion around key themes that groups preparing for a transaction process should be mindful of, what investors and lenders should be mindful of as well as they continue evaluating the healthcare space. We'll plan to have Katie's contact information in the show notes for anybody who's interested in reaching out to her. And we'll plan to have our contact information in the show notes as well. But Katie, really appreciate your time and looking forward to our next conversation.
All right. Thanks, AJ.